gentlemen, thank you for having us today in this Facebook Live. We are live right now with Ms. Margaret W. Wong, who has been an attorney for more than 40 years, more than 4 decades, working with the immigration system and helping a lot of people get a relief in their immigration situations. So, if you are a person that came to America for some reason, you weren't born here, and maybe someone said that there was no hope for you or there was not a possibility of a relief for you, this is your chance to get an answer in your questions. And we have Ms. Margaret Wong, who has been working for more than 4 years. Ms. Wong, thank you very much. And good afternoon. I hope you had lunch already.
Yes, I did. And thank you.
Thank you very much, Ms. Wong. So, a lot of people asking questions this week through our social media, Facebook, Instagram. But I would like to start talking about what's going on with DACA and the public charge. We know there's some fights or battles that are being delivered in the Congress and some other parts of the government.
Yes. So basically, the nice thing about immigration is they reopen on June 4th. So immigration is divided into three departments. The CBP, which controls the entry. So you have three ways to come to America: air, land, and soil. You walk. You flew, you walk. And anyway, so there are three ways. So CBP controls that. CBP never really closed because people do have to come. They may be subject to 14-day quarantine. CIS actually closed for some time and reopened on June 4th. So CIS controls the naturalization, the citizenship, controls work permit, asylum grant, green card grant, citizen grant. So, but before we can do all that, we need USCIS to give us fingerprints and, do the hit with FBI. That department closed and reopened on June 4th. So regarding the June 4th date, right now, even though we're reopened, we cannot go in unless it's 15 minutes before your reopening, your appointment. You have to wear a mask. If you had 14 days been in touch or have the virus, you could not go in. So these are the rules. Regarding naturalization, they're also starting, but right now there's really no fingerprint notices yet. So really things are in the air. As far as the courts are concerned, there are three courts that definitely have information on reopening, but we are pretty sure they should all be reopened by June 29th. But at this time, there's really no records because courts are very much controlled by DOJ. It's not really a Department of Homeland Security stuff. So that's where we are regarding opening and closing and the mask. Another issue is public charge. On February 24th, oh my gosh, is it February 27th or 28th? On 2020, there is a new law on 944 called I-944. So if you Google uscis.gov on 944 form, it's up on that day. And that specifically talk about public charge. Public charge law has always been on the books for immigration for as long as I have remembered. I've been doing this for more than 45 years. Public charge means that you should not be getting Section 8 housing, cash, open quote, close quote, cash assistance, and also anything that's like Medicaid and food stamps and stuff. But as of February of 2020, I-944 came in. What does that mean? That means that anytime you're only applying for adjustment of status, that means you're changing a status from a student, F1, to a green card, or changing from a tourist visa to a green card, the alien need to fill out the 911. It's that simple. It does not apply to if you are sponsoring your parents from China. That you don't need 911. That's public charge number one. Public charge number two means that on the form, they ask you for your credit listing. They ask you were you ever on public charge. So what's the definition of public charge in relation to COVID-19? Right after March 17th of 2020, the whole United States started, especially New York, in shelter in place. So public charge also came in because in the meantime, I have a work permit. Now I'm applying for citizenship or green card. Could I or could I not get the $1,200? Is that public charge? Could I or could I not let my children get the $500 even though they're American citizens or they only have a work permit? Could I or could I not get unemployment compensation even though I paid my tax and it includes unemployment, the insurance to get unemployment from the government? Absolutely, that's not public charge. Now, the question come in on state levels. Different states have different COVID-19 help. Ohio is rather stringent because we're not a rich state. New York is very liberal, especially New York City, have always been very liberal on Medicaid assistance, on cash assistance. So the question is this cash assistance public charge, even though we are all suffering, even though everybody is getting the 1,200? That's the issue now. Right now, there's really no answer. Immigration like us, immigration lawyers like us, we are studying the issue. Lawyers love to talk and we love to read and we love to think we're the best. I mean, that's our vanity speaking, our ego speaking. But the reality is right now, nobody knows if cash assistance under state COVID-19 assistance is a public charge because it depends on if it's COVID income maintenance or if it's other emergent circumstances. So it depends on the definition, we will know better. So I will come up with more answers as we study more the issue, because right now the federal government CIS is not telling us which cases are being granted, which cases are being denied, because they just reopened.
Yeah, that's a very good answer. Thank you very much, Ms. Wong. And if you have any questions, just give us a call, 216-279-3984, 216-279-3984, and Ms. Wong is going to be answering more questions. So the good news right now is that Ms. Wong is already starting to travel in the next couple of weeks. So if you want information about when she is going to be in your city, either Atlanta, Chicago, Cleveland, Columbus, Memphis, Nashville, and the city of New York, and Raleigh, North Carolina, so just call 216-279-3984, and she will be happy, or they will be happy to give you all the information. So we have several questions coming in through our Facebook Live, and if you have more questions, just write them down, and we're going to read them for Ms. Margaret W. Wong. So the first question: I applied for a tourist visa extension because of COVID in May. They only sent the receipt notice and nothing else. I should exit by August. What should I do if I don't get any update before August? What would happen to me? Thank you.
I don't see a major problem. I hope on your I-539, that's the extension form, you attach, the COVID-19 information, because even though the whole world knows we have a COVID-19, we cannot travel, immigration sometimes don't have a good memory. I mean, they only look at your filing to tell them what we told them. When you leave the country, make sure you return the I-94, or make sure, actually, the new law is you don't have I-94, you just have the stamp. So make sure when you leave at the ticket counter, they know you left, all right? Because it will be reflected on the USCIS and the ICE locator. That's where they find when you came, when you leave. Then the next thing is whenever you come back, there's certain nicer airports, there's certain meaner airports, and I don't want to talk in front because I don't want the CPP people to kill me. But make sure you come through a more friendlier airport and explain that last time you timely did an extension, but you never got an answer. I firmly expect those cases to be approved. Make sure that address that you leave, that CIS either withdrew the application, lets you, or approve it. Because if it's denied, it would be a little bit more difficult to come back. Because if it's denied, it's considered your stay expired whenever it expired because it was never approved. But if it's approved or withdrawn, then they know that you left, so you never overstay your visa. Because if you have a 180-day overstay, you cannot come back in 3 years, even though you have that stamp. Or if you overstay for 360 days, you can, and I don't know why they didn't make half a year or 1 year. They make 360 and or 180. It's weird. So you're short 5 days, So as lawyers, I always have to remember it's February 24th of 2020, it's March 17th or 20. It's just that 1 day difference kills my case. That's difficult. So make sure you don't overstay 180 days, 3-year bar, 360 days, 10-year bar. So you need that receipt, and you already say you got it. When you leave in August, make sure when you come, leaving is not a promise. Coming back, that's the issue.
Okay, and that's very important to know, because some people just do it, and when they are coming back, they are just sent back to their countries after being detained, or technically detained in the airport for several hours. So before you do anything, just give Ms. Wong a call, 216-279-3984, 216-279-3984, and keep asking just your questions, because we are live and we want to give you the opportunity to hear from Ms. Margaret W. Wong. She has been working in immigration matters for more than 40 years. So next question is, do we have to file I-944 for existing H-1B?
That's an interesting question. H-1B, you should have a good lawyer. Normally, the employer already have filed, have a lawyer. H-1B visa, I would not file it on your own. And when you say the I-94, it depends on when you left, when you come back. What is the I-94? I-94 means that when you enter or when you do an extension of the H-1, they sometimes attach at the bottom of the 797, the small I-94. But the past few years, when you come to America, normally in a major airport, a major landing spot, they don't even give you I-94. They stamp the passport, and you can get the ICE locator by typing in USCIS.gov or what's my I-94 status. It'll all show up. Now everything is in Google, is in computer. So it depends on if you're doing extension, you're doing a change of employer, you're doing a change of status, or you're doing a 7th-year extension, because H-1B is only for 6 years. Then you need or need not do an I-94. But most new entries, you don't even have a new I-94. You just have to stamp. And whenever you leave, the ICE locator would have it. Whenever you come back, they restamp it. You can also use the old visa. So, for example, I work for Eaton Corporation. I have a stamp on a 3-year H-1B from the American Embassy in Mexico for H-1B or TN visa from Eaton. Now I switch my case. I got a better job offer from H&R Block. So now I can actually go back and forth with the H&R Block job offer letter and a TN approval or H-1B approval, even though the stamp says Eaton. And don't forget that you don't need to go back and stamp a new visa, because sometimes when you go back and stamp a new visa, that's all. Like if you have a DUI, they may deny it. So I would not use a new stamp. I would use an old stamp to come back with the new visa, with the new job offer. Sorry.
Yeah, no. That's awesome. That's awesome. Very, very clear, the explanation. So more people are sending their questions through our Facebook Live. So thank you very, very much for all your questions. We're going to go to the next one, but there's another part of the question that Jada sent, and she's trying to clarify her question. And she says, for I-944 declaration of self-sufficiency.
Yes, the 944. Yes, the new law that came in. So perfect. What's the question? Yes.
No, I think she was.
Oh, she meant 944. No, not I-94.
Stimulus check.
Oh, no. Stimulus check's not public charge. Don't worry about 944. If they ask, you say, yes, it's only $1,200. That's not public charge. Okay. There's nothing to be worried about. Oh, so her question is I-944. Does it affect the $1,200 because she got the $1,200? And she had a visa. Absolutely no problem.
Okay. Thank you very much for your question, and thank you very much, Ms. Wong, for the answer. The phone number, if you want more information, and if you want to know where she is going to be within the next month, just give a call, 216-279-3984, and she will be happy to take care of you. So, Ms. Wong, how do you feel about reopening the office for the public next week?
We are talking about it. Right now, my flights are booked, but I also have some advice from my friends, from my clients, saying that it's still better not to travel and better not to reopen. So as of today, it's just I'm working like immigration now. Who knows what tomorrow brings? But as of today, I'm talking to a lot of clients on the phone, on Facebook, on Zoom, but we have not personally seen clients yet. I already have a lot of requests, so we may or may not reopen next week. But all my flights are booked. We are planning. We already have our plastic out. We already bought like hundreds and hundreds of masks, and the temperature we're all ready. But personally, I really have a problem. And I think it's really very much for public safety. It's not just for me and our staff. We are still, half of our staff is working, 3/4 of our staff is still working at home. And even if I'm ready to see clients, I don't want them to come in because we need to maintain safe distance. And I'm not encouraging our litigation lawyers to also be traveling. We have cases in California and Detroit in July. We're asking for postponement. We'll see how they respond. Yes.
Okay, it's good to know that. So call for more information, 216-279-3984. More questions. Does the COVID-19 delay any processing of new or old applications?
No. It should not delay it, especially for work permit. The government already told us work permit will be and could be approved without fingerprints, number one. Number two is right now they're doing premium processing again on H-1B. That means if you pay another like $1,200, they'll make it in less than 15 days, approve your H-1B. So they are, because they're short of money, they're talking about to Congress for 10% more for filing fee. But right now, there's no additional filing fee. My recommendation, if you qualify for citizenship, apply now. If you qualify for work permit, I might apply now, and don't worry about the slowdown. Until you apply, the slowdown does not even apply to you.
Yes, and I think it's even a little faster probably because maybe they were not that busy taking care of people in person in the offices. So if you want more information, just give us a call. It's 216-279-3984. We have another question. Can I get an ITIN number when I overstayed on expired passport?
Answer is yes. You need to go to H&R blog or talk to any of these tax people like Nashville. You can actually you don't need even to mail them your passport. You can just go to a certain address and show them the passport, and you don't need normally to get a tax ID number. That's you file this W-7. I would recommend you go to a bookkeeper or go personally to the tax office and show them the passport. But most tax offices will not like to do that because they're worried about losing your passport. So you have to mail your passport in and come back. But like the Nashville one, that I know because we have a big office in Nashville. They will do it. I think Cleveland may do it and Columbus, but I'm not sure because they change. So make sure you don't lose your passport. But yes, you can get a tax ID number by showing them your passport.
Perfect. Thank you very much, Ms. Wong. One more question is from Dharmesh. Hi, my parents are green card holders. They left USA last year on June 16th, 2019. What should they do if they can't come to the US before June 16th? Thank you.
Okay, so the law is not, this is a very good question. The law is no longer 1 year. In the olden days, you have to come, if you have a green card, you need to come back to the United States within 1 year of your last departure. The law now is 6 months. So Mr. Damash, you need to make sure your parents should have come back before December of 1919, because 6 months from June 1919 is December. But since they did not come back in December and now it's up to June, they should really, really come back. Don't go through because India have a better flight and connection through Dubai or one of those Middle Eastern airports because they're trying to make them international airport. I would not go through that spot at that airport because that's a very tough airport, especially for direct people who wants to go from India through that for transit and come to America. I would find the flight that goes to Atlanta. The reason is that I do a lot of Indian cases and they always are prompt, especially for older people who did not come back within a year. So I would find a flight that goes to Atlanta. Really try to come back before June. If not, if they couldn't, try to come back as soon as possible after June, because less than 6 months, we have the burden of proof. The alien, the burden of proof, or could be the other way around, that we did not give up a green card. More than 6 months, but more than 6 months, but less than a year now. It's a year now. It's not 360 days. You government have to prove that you gave up a green card, or the other way around. I always get those two things mixed up. But after 12 months, you have a problem because technically your green card is gone, even though you do have a 10-year case. You have a 10-year green card. So the answer is two. Number one, do the best you can. Have parents bring all the COVID stuff that they could not come back in March, because India COVID started, and Damesh is Indian. COVID started in January. They just didn't report it. So if you cannot come back until after June, show you bought tickets, you did everything you can, and dress nice, dress expensive, show respect. Don't come in like a beggar, because let's face it, the richer you are, the more America would welcome you, and come in with grace and honor and respect. Don't start yelling and screaming and say, oh, I was sick. Bring all the medical, bring all the COVID, and say you just couldn't come back because you're old. And you couldn't afford to lose your health since January. China and India started COVID in January or even December, right?
Yes, and we were really scared that you were traveling around there in January, and we just wanted you to be back in the U.S. as soon as possible. But you are healthy and you're good.
Yes, thank you.
So we have a bunch of questions. We're going to try to answer all of them. So this next person, Caroline, she says, I live in the United Kingdom and I have my job here. I have been working from home since March, and I really want to go visit my parents that live in the United States. I am Venezuelan, and I would like to know if working from home, being in the United States, since my job is in the UK, if that would be an immigration issue for me or not.
That's a very, very good question. She's a Venezuelan. She works, her paycheck apparently came from UK. She probably is a British national, but I wonder what passport does she carry and what visa, because if she carries a British passport, she has two tourist visa type. One is a 90-day visa, ESTA, what we call ESTA. There's a visa waiver. You only allow 90 days, but as I said earlier, you have a 30-day extension now. So she wants to visit her parents. The second issue is I presume she doesn't have a work permit, but she works for a company in UK and she's sheltered in place working for UK. As long as a benefit, she's paid in UK. She's not working in America for an American business. It's a questionable area. And let me give you another example. I'm a tourist in America. Cleveland Playhouse, we hire a lot of we invite a lot of volunteers to lead the patrons to listen to a play, and we give them free tickets. Is that illegal work? Because I'm only volunteering, but I get free tickets from my work. So that's considered illegal work. Her question then is, and I don't necessarily know what kind of job she does, but if the job benefits UK, she's only here on vacation to work for a UK company. She's not being paid here. She just was here because she's stuck. Then she would say, I would assume that she could, and she's not working illegally. That's
okay. That's perfect. Thank you very much, Ms. Wong. Okay, more questions coming in through our Facebook Live. So thank you very, very much for every single question. So the next one is there a law that allows you to file for a green card if you have been in the US for a certain time with valid record of maintaining a good status?
The only thing, there are two ways, the three ways. Number one, if you have 245I, that means your parents were here and filed something, or the uncle and auntie filed for the parents before April 1. Or if they were filed before January 14th of 1998, or before November of 1997. That's what we call 245I. Then you can file a perm, you can marry a green card, you can do a investment visa, you can still get the green card, number one. Number two is if you came to America undocumented, but somehow within 6 months or 1 year, especially when you're under 18 or under 21 and got TPS, then maybe I can still get your green card because TPS is a status. Or if you're on an F1 but you're overstayed and then you still had a work permit, there are ways to do that. Then you can still get a green card even though you're illegal, but you have a work permit. The third way is somehow if you have parents who have green card or spouses who have green card and you have a perm available, you can still go out of the country and come back with a 601A for pardon for the waiver and you'll get the green card. But you would not be able to get the work permit in America. So there are ways, but depends on how lucky you are. And, each family is different.
Yeah, that's good. And thank you very much for the answer. More questions coming in, Ms. Wong. Take says, DACA work permit is going to expire this November. Is it advisable to renew it right now?
Oh my gosh, I'm so glad you asked that question. The answer is 1,000% file it now. You need to do the 821 form and the 765. 2 forms. You need to file it now. Even if you have a DACA that expires like in December 2021, also file the extension. The law had always been you have to file work permit only 150 days prior to expiration. DACA law change. File all DACA regardless of expiration. File a new one now because the U.S. Supreme Court may or may not come down denying all DACA. Then it's up to the Senate and Congress to protect the 800,000 young people. So the answer to that is file it now. Whatever U.S. Supreme Court do and whatever Senate and Congress do, you're protected at least for 2 years. Also, the good news is I've been doing a lot of DACA extensions. Mine has been approved sometimes in 3 weeks, 6 weeks, 12 weeks. So I think immigration have sympathizing. I mean, I shouldn't tell that because the president would get upset at us. But I think immigration now is also expediting the DACA approvals. Maybe not, but I've been getting my DACA approval. So file it now, even though it doesn't expire or expire more than 150 days. File it now. All DACA should file it now.
Okay,
You don't even need a lawyer to file DACA. Just do it, please.
Okay, just do it. And if you need more advice, just ask Ms. Wong to help you with that. And okay, so the next question. I'm a United States citizen, 66 years old. I also have a Canadian permanent resident status, and I would like to apply for the Canadian citizenship. Will I lose my U.S. citizenship if I apply for the Canadian citizenship?
That's a really good question because Canada have very good health care. So once you got American green card and American citizenship, and if you only have a Canadian green card, you don't get their health care. That's why a lot of American people around the world, they want Canadian because they have national health insurance and they give you a lot of benefits if you pay tax for the past 5 years, 10 years. Canadian benefit is always better than America because Canadians are a little bit more socialist. And it takes them only 3 years to get citizenship, while America takes 5 years. The answer is, and actually I don't know that. I know the answer, but it's weird. Like Israel, they approve dual citizen. So even if you are an American citizen and you go to Israel, apply for citizenship or get citizenship, if you go to Europe, you can either use Israeli passport or American passport. So in America and I don't know about Canada, I only do America. America only allows one citizenship. You're already an American citizen. And because you only have Canada landed immigrant, you could always keep American citizenship, but now you're getting a Canadian passport. So if you travel in Europe or China, you could use a Canadian passport because they don't murder Canadians as much as they murder Americans, or India or Russia or something, because they love Canadians, but they don't like Americans. But if you come back to America, you have to use an American passport. But I don't know the answer is that once you became a Canadian, I know if you were already a Canadian citizen, you apply for American passport, you can always get an extension of American passport because America will not, because you got American passport second, but America don't allow dual citizen. So the question more is if I travel to Europe, can I go to that country with my Canadian passport? Because most people, especially if you go to Arabic world, it's always better to go to a Canadian passport than American passport. Yeah.
Okay, thank you very much, Ms. Wong. And this last question, so is it okay to file I-944 for the existing H-1B, and who should file it? The petitioner or the beneficiary?
944 is always filed by the alien, which is the beneficiary, because H-1B is the employer's filed petition. So the employer could be a person, could be a corporate, could be a partnership. So employer don't file 944.
Okay, so for this person, if they have to renew the H-1B, they need to file the I-944.
I thought H9, and I'll get you an answer or put it in your Facebook. I personally thought 944, because it's a new law, only applies to green card application. I don't think I-944 applies to H-1B.
Oh, okay.
But I will give you an answer later. Can someone ask Francis, the upstairs department, to see if 944 H-1B extension needs 944? Okay. If you ask me another question, I'll give you an answer. I'll call him right now. I'm interested in this answer too, because I don't think you need 944 for a non-immigrant visa application. Yeah.
So, so we have more questions. Now this one is about the public charge. Does the public charge apply for all the immigration relief or adjustment of status, or just for some cases?
Wow, today is all 944 questions. Public charge. So what's the question? Public charge.
If it affects the immigration process for all kind of cases.
No. Public charge. So if I'm on public charge, I'm a green card holder for 10 years. Now I apply for citizenship. Public charge does not apply. It only applies to adjustment of status to green card.
Perfect.
That's why I'm surprised at that. But I may have missed something. I'm asking I have lawyers here that's better than I am.
Yes, perfect. With a pending asylum case and an expired I-94, can a person do a change of status to R1 visa?
The question then becomes is if I'm undocumented, if I'm illegal, can a church or religious organization sponsor me to get an R visa? The answer is no.
Okay, perfect.
Unless it's a green card, which is a 360, because R1 is an I-129. Unless I'm applying for a green card and my I-94 expired for less than 6 months, because for employment-based green card, you're allowed 180 days out of status for grace period. But for non-immigrant, there's no grace.
Okay. Well, we have exceeded our time live.
I'll give you an answer later. You can put on Facebook.
Okay. So Jada, Ms. Wong is going to answer your question shortly. And thank you very much for.
Okay. The answer is no.
Ms. The answer is no. Okay.
Yeah. The answer is no. Yeah.
Okay. That's good. And this is what makes people love Ms. Wong, because she wants to give an answer, first of all. And second, she has 16 other attorneys working with her, and they all have updates in every single part of the law. Some of them are litigation attorneys. Some of them are
family-based. They're so good. I'm so proud of them. I always tell them I need to learn from you, because I'm always in the office answering kinds of questions, reading new law, because every Saturday morning, that's my job. Because Friday night, my law clerks print me all the new stuff. And it's my job to finish it by Saturday and have our staff meeting Mondays with our lawyers to talk about new stuff, DACA extension. Should we do it now, or should we advise to wait for 150? Because you can save some money if you wait, but I'm really worried about the U.S. Supreme Court case. So a lot of DACA kids, and today I'm learning from you, because now we are learning public charge is a major issue. So I promise you I'm going to learn more about 944.
Yeah, that's good, Ms. Wong. So is it okay? One more question?
Yes.
Okay. So When is it time? When is the immigration building supposed to open? My husband needs to get fingerprinted.
Okay, June 4th. And you need an invitation letter to do fingerprints. So don't walk in there. They won't let you go in.
Okay. And the last, very, very last question, and we say bye. I am Colombian. I live in Costa Rica. I have a tourist visa, but I would like my children to study in the United States. Can I do that from Costa Rica, or they need to go to the U.S. and find a place?
From Costa Rica, because then you save a lot of legal fee. The question is, I have a tourist visa. I'm worried because if they don't, American embassy doesn't approve my children's tourist visa, they make student visa, they may cancel also my tourist visa. So should I take a chance, apply for student visa in Costa Rica, because we are third country national, we're Colombians, we're not Costa Rican. So if they deny my kids the F1, would they also cancel my tours? That's the first question. The answer is yes, they may. So another way to do it is to, on the other hand, if you come as a tourist, after 90 days, get a high school or grade school, private school, because public school does not give I-20 F1. You have to do a parallel track. So that's a lot more filing fee and legal fee. So the best answer to that is get a good school, apply for student visa back in Costa Rica, and come to America on F1, the parochial schools. The tuition is about $8,000. We do a lot of that kind of work, right?
Perfect. Thank you very much, Ms. Wong, for all the answers, for your time, and for giving an answer to everyone who asked a question today. So next appointment with Ms. Wong is going to be next Thursday, 12:30 p.m. Eastern Time. And if you have any questions, just call for more information, 216-279-3984, 216-279-3984. And I just want to advise people, if there are some other questions that you can have, maybe you can go to Spotify, and Ms. Wong is talking about many immigration details on her podcast, more than 42 episodes of podcast, and also on YouTube channel. You can see more videos where she's explaining some other details about public charge, H-1B visa, B-1, B-2, adjustment of status. So everything is just there on YouTube channel. So just find it as Margaret W. Wong and Associates, and you will find all the information. Thank you very much, Ms. Wong, for your time, and have a good afternoon.
Thank you, and I love you all. Thank you.
Thank you. We love you too. Thank you very much, everyone. And don't forget the phone numbers, 216-279-3984. Margaret W. Wong and Associates, more than 40 years of experience.